We disagree with the rulings of the Supreme Court. We will continue with the case. You all see what will happen in the Supreme Court.
We'll hear from lawyers of President Akufo-Addo who dispute the claims of unfair treatment, arguing sound legal knowledge won over emotive arguments.
The law is not about what you want. It is about what you will get. When you come to court and your mind, with all due respect, is jaundiced, that you should expect a certain ruling from the court. If you are emotional about a ruling, that is what you will get.
Top story is brought to you by Belacqua Mineral Water, Gassam Cement, the nation builder, and Vodafone. The future's exciting. Ready? I am Ernest Manu. The quest by 2020 NDC presidential candidate John Dramani Mahama's lawyers to get the Electoral Commission chairperson Jean Mensah to answer 12 questions has failed yet again. A 9-member panel of justices this afternoon dismissed Mr. Mahama's review application. Now, the court presided over by Chief Justice Kwesi Enin-Yeboah said the threshold required for the court's review jurisdiction to be triggered had not been met. The Supreme Court, constituted as a 7-member panel last week, ruled that the EC chairperson should not answer the 12 written questions, which included whether or not the NCA assisted the EC in the transmission of election results. Court correspondent Joseph Akablay joins me in the studio with more on today's proceedings. Joseph, so we had 2 breaks preceding 2 dismissal of 2 applications. Let's start first with the application to file further submissions as far as the review is concerned.
Yes, and so that particular application was made by Mr. Chikata. It's important to point that 2 justices joined the 7-member panel. It had to do with Justice Amadou Tanko and Justice Professor Henrietta Mensah Bonsu. So the 2 joined to make the panel.
So we had 9 instead
9
of the usual
yes,
7 that we've seen so far.
Just to deal with this particular request. And so the request was to the effect that Mr. Chikata was asking to be allowed to file additional documents in support of their review request. And he was saying that they wanted to point out a constitutional provision that they deem relevant to a determination of this particular issue, saying that the court has a right to allow for such applications if it finds it important to determining a matter. We can listen to bits of the arguments.
It is on the basis of those provisions that the Supreme Court in 2013, in a petition brought by Nana Addo Dankwa Akufo-Addo, had recourse to Order 22 of CI 47. Our submission is that it cannot be that just because this petition is by John Dramani Mahama, it cannot be that it cannot be.
Please, let's try to.
My Lord, it's okay. Respectfully, my argument is that there cannot be a different interpretation of the law.
With due respect, if the 2013 case is cited, then it will be clear to all of us. That's my worry. What I'm saying is that if it is a reported matter, yes, if it is cited in course of arguments, yes, that would be the appropriate thing.
Mr. Chigata, and additionally, the 2013 election petition was not done under CI 99. So that is the change, rather than the personalities. I think you.
Yes, my lords, I believe I have indicated that nothing, that's my first argument, nothing in CI 99 took away that authority. I've indicated that. And therefore, and building on that, I'm saying that it cannot be any different from one petitioner as against the other. We'll leave out the names of individual petitioners, but it cannot be different as between one petitioner. The reason I respectfully say that we are guided by the practical wisdom in Mr. Mafusa's book is that in any case, Your Ladyship, if the questions are not relevant, how can they be allowed in cross-examination, if that is the position? If the questions are not relevant, if that is the position that's been taken, then they cannot be asked in cross-examination either.
Are you attempting to cross a bridge you have not reached?
Well, I believe you put that bridge there. Your ladyship put that bridge there. And therefore, I had to deal with that bridge. Your ladyship raised the issue.
And so that is lead counsel for the petitioners, Mr. Chachu Chikata. And let me just state that this is his argument on the substantive application for review.
Yes.
Because
so
the initial...
Relating to the initial one where a request was made to add additional documents in support of the review and also to change a paragraph in the review, the court turned that down.
That was dismissed.
That was dismissed. The position the court took was that granting that request will mean that it's expanding the scope of its review under its inherent jurisdiction. And so by unanimous decision, it turned that down. And so after it had turned that down,
then they had to argue.
Argument took place where Mr. Chikata was making the point that the judge's interpretation of CI 99 sought to suggest that the CI 99 had taken away the powers allowing persons in such a case to administer interrogatories. And the point he was making was that there is no express provision in CI 99 that bars the courts from allowing for interrogatories to be administered. And he made reference to the 2012-2013 election petition to say that it was allowed in that instance. Nothing has changed since then. The only thing that has changed is a law that says the case should be determined expeditiously. It has not taken away that power, and so the court should grant the request.
He further made some references to authorities in the Nigerian Supreme Court and urged the Supreme Court to grant the review. But then we had the first respondent also argue against the application, and lawyer Menive did that rather briefly. Joseph.
Yes, the point he made was to say that in terms of the court's review jurisdiction, it's a small window, and if you are coming in to seek for such an opportunity, you should demonstrate that there's an exceptional circumstance or there's some new information that has come to your knowledge that you are putting across to the courts.
The submissions that we have heard today have not canvassed any new matter or exceptional circumstances for which this court's review jurisdiction should be exercised. My lords, what we have rather heard was a rehashing of the arguments that was before the court when the decision was taken on the 19th of January. In this regard, my lords, may I humbly read the decision of Adade GSC in the case of Mechanical Lloyd Assembly Plant versus Nati. It says, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer along with the evidence grounding it can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision will be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. A review jurisdiction is a special jurisdiction to be exercised in the exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor as an automatic step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. My lords, it's my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting Adade, and therefore this application should be dismissed.
And so that's the counsel for the first respondent, that's the Electoral Commission, also arguing against the application for review. We had the lead counsel for the President Akufo-Addo. What were their arguments?
Mr. Kutampa told the court that as far as they are concerned, the applicants, that is the petitioners in this instance, had misunderstood the court's earlier ruling on the interrogatories.
CI 99 prescribes strict timelines. Therefore, the court will not apply Order 23. In this circumstance, what is meant by this circumstance? That is all the issues that have been looked at or discussed in the ruling. We all know that when you are doing interpretation, you do not just pick one sentence or paragraph out of a whole construction and make a meal out of it, as counsel for applicant seeks to do. My lords, let me then make the point that the reference to the monarch case, my lord, is misconceived and involves a deliberate attempt to put an impermissible spin on the monarch case for purposes of this application. In the monarch case, what the court held was that rule in CI 74 that sought to take away the right of review was unconstitutional.
So you had the lawyer Kutampa, who is a lawyer for Nana Addo Dankwa Akufo-Addo in this election petition case. Let's go on to the phone lines now and speak to a member of the NDC legal team, Eduji Temaklo. Thank you very much, sir, for your time here on Top Story. Now, I want us to start by listening to the former Attorney General, Marietta Buapialpong, who is a member of your team. She spoke to the media, and this is what she said.
When you examine or when you listen to the ruling of the court, the only reason they give is that the rules do not allow for it. So if the rules do not allow for it, why has it been permitted in the past? And so we think that the petitioner is not being treated fairly in these circumstances. Counsel for the petitioner made reference to a specific case, Ernest Manu, in which that related to an application for leave to file supplementary. Now, that particular case, they were allowed to file a supplementary statement of case. The Supreme Court claims that it's distinguishable from this one. We disagree. You all heard the very superior arguments of our counsel. He said there were fundamental errors. When did Jean Mensah, for example, discover that she had made errors? What was the process by which she corrected those errors? Who did she consult in correcting those errors? Did she consult the agents of the candidates? And so we disagreed with the court and thought that the petitioner has been denied a right to a fair hearing. And we referred to cases which said that if a petitioner, on grounds of expedition, is denied a right to serve interrogatories, that is a denial of a right to a fair hearing. Right. The refusal of our applications are not fair to the petitioner in the light of the past and in the light of what is happening now. We disagree with the rulings of the Supreme Court. Unfortunately, that's their decision. There's not much we can do. We'll be in court tomorrow to start our case. We are not withdrawing our case. We will continue with the case. You all see what will happen in the Supreme Court.
And so, Mr. Tamaklo, that is the former Attorney General, Marita Buapiopon, a member of your team. She starts by saying that the justices did not grant the review because the laws simply do not allow for that. But when you listen to Justice Eniebua, when he delivered the judgment, he said that the application for the review did not meet the threshold. And he gave two indicators. One, that's there's an exceptional circumstance which has resulted in the miscarriage of justice, and the other, which is the discovery of new evidence which was not available to the applicant at the time, or that the applicant could not produce that at the time the decision was made. If she then proceeds to say, based on this, that the decision by the court was unfair and that you have been denied the opportunity for a fair trial, how justified would that be?
Okay, thank you, and good evening to your viewers and listeners. I think that if you had listened to the learned former Attorney General, you would notice that the review application is in respect of the ruling dated the 19th of January, in which the court dismissed the application for leave to administer the 12 questions on the chairperson of the Electoral Commission. That is the ruling that the application for review was filed in respect of. And so the point she is making, and which was a submission made by learned counsel Mr. Chikata on his face, is that their decisions, albeit persuasive, to the effect that the essence of interrogatories are to assist the courts, and therefore a party who has been denied the right to administer the interrogatories had been denied the right to a fair hearing. That was a submission made before the court. I do appreciate the challenge you have in just quoting what the Supreme Court said by way of the fact that the review threshold has not been met. If you listen to Mr. Chikata very well, what he said was that the one instance where the review jurisdiction can be invoked is where a fundamental error of law has been occasioned. And the nature of the error of law is said that it has occasioned what you call a miscarriage of justice. And so he demonstrated what it is. You see, like it has been suggested, in one breath, we have been told in the 19th January ruling that the 12 questions are irrelevant. Now, it was on the 20th that the court set down the issues for the trial. But what benchmark was the determination of relevancy made? And like you saw Mr. Kotuampa today, he fell into the trap by now telling the court that you have set 5 issues down. How does these 5 questions relate? What is the nexus between the 12 questions and the issues? Question to Mr. Ampa. At the time when the ruling was delivered, were issues set for trial? No. There was no issue set for trial. So you cannot now use issues that were subsequently set down for trial as the basis of determining relevancy that was determined earlier. And that is why the learned former Attorney General made the point that it speaks to the petitioner's right to fair hearing. And in moving the application for review, our respected senior counsel and lead, Mr. Chachu Chikata, in referring to the Nigerian Supreme Court decision in the case of Abubakar and Yaradua, makes it very clear the authoritative pronouncement of the court then that such a denial or a refusal amount to a denial of the right to fair hearing. And that's the point that Marietta will appear upon, the former Attorney General, basically reiterated when she spoke to the press.
And so you have the you have the opinion that you met, and this is in respect of the review today, which was heard today, that you met the threshold, the first one, with the Chief Justice stated, of a situation where this may result in the miscarriage of justice. You think that there is cause for that?
If I may ask you, when you say miscarriage of justice, is it a technical term? Or
no, you tell me. The court is saying
exactly the point I'm making. That there are judicial pronouncements to the extent that when you deny a petitioner the opportunity to administer interrogatories, it amounts to a denial of fair trial. If someone right to fair trial is denied, you think that is not miscarriage of justice? We made that submission before the apex court of the land. And we told the apex court of the land that this is not the first time you are administering or you'll be asked to grant leave or permission for interrogatories to be admitted. In fact, the apex court had delivered itself in 2013. At that time, in 2013, it was the same, more or less, parties, the Electoral Commission, John Dramani Mahama, Nana Danko Akufo-Addo, Baumia, and may his soul rest in peace, Jake Obeche-Bilante. The only thing that is different from this current petition is that the person that the interrogatories were administered on in 2013 was Afarijan. This time, it is Jane Mensah.
Mr. Temaglo, are you of the opinion that you have hit a snag as far as these 12 questions are concerned, and that you think that legally... is it your opinion that there is no opportunity, there's no window of opportunity to raise these 12 issues that you'd want the Electoral Commission to respond to once the trial starts?
You've asked a very intelligent question. Now, when a court describes 12 questions as irrelevant, okay, and now the court expects, by way of the question that came, that under cross-examination, you should ask the 12 irrelevant questions. Will it be admitted then, at that time? If the thing is irrelevant today, by close of day tomorrow, would the relevancy change? Definitely not. And you see, effectively, what you have done is to arm the respondents with an objection to be taken, even if of those questions are asked. All they will say is that, my Lord, your ruling dated the 19th. This is what you stated, that those 12 questions are not relevant. And to the extent that they are not relevant, we object to it.
Mr. Temaglo, hold the line for me briefly. Let's speak to private legal practitioner Martin Thidbu. Thank you very much for joining us here on Top Story, Mr. Thidbu. Now, you raised, and I want to start from the last point that Mr. Temaglo just made, that in 2013 it was granted. This time, the judges say they did not meet the threshold, and in fact, initially they had said they had raised issues of relevance. Now, when you consider the two facts of the case, do you think that in this case that justices should have stuck to their own judgment in 2013 and granted same?
Okay, Ernest, you see, there's one cardinal principle, or let's say law, that we can't run away from, which is that the Supreme Court can always depart from its previous decisions. So, though you find that in the 2012 petition, they said they were persuaded to apply Order 22 of the High Court rules. In this particular one, because of the 42-day there's a time limit, you could see, reading from the ruling, you could see that was one of the factors that influenced the court. The court has departed. Look, Ernest, to be very candid with you, in this matter, let's look at the substantive matter. Okay, moving forward, Mr. Manu's lawyers can ask those questions when it comes to cross-examination. So, for me, that is it. If it were that they would never have an opportunity to ask those questions, then it would be so much of a big deal. But to the extent that they can have another bite at the cherry when it comes to cross-examination, I think we should let matters stand as they are now and wait for the cross-examination.
But then the issue he makes about the possibility of an objection being raised by counsels for the first and second respondent and citing this ruling of the court is also a genuine concern. Would you not agree?
Oh, yes, theoretically, yes, they can do. But don't forget that practically, the judges, there are a number of principles at play when it comes to cross-examination. Sometimes you start on a very tangential level in order to zoom in on the substantive one. So in one word, there's a lot of laxity. Lawyers are given a lot of scope in cross-examination. So on the balance, these questions will get through. Today, at a point in the proceedings, did you hear the justices say that Mr. Chikata can ask those questions in cross-examination? Did you hear that?
Yes, counsel, count that again.
Yes, I'm saying that in the proceedings today, I think there was an indication to him.
Yes, that is Justice Professor Mensah Bonsu raised that issue, yeah.
Yes, and look, and if we open Order 22, maybe we should have started from there. If we open Order 22 right now, I have it here. It's expressly stated that you can ask in cross-examination. Let me go to 22. There is a point, I think if I remember off the top of my head, yes, there is the point that you are not precluded. Yes, and by our even mentioned it the last time. So Order 22, 1.6, it says that a proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in oral cross-examination of a witness. Yeah. So you see that when they disallow it here, it doesn't mean the door is shut forever. There's an opportunity to ask in cross-examination.
Thank you very much, private legal practitioner Martin Pebu there, and thank you very much, Ediji Temaklu, for joining us. That'll be it for Top Story, brought to you by Belacqua Mineral Water and Gasem Cement, the Nation Build, and Vodafone. The features exciting ready. The case has been adjourned to tomorrow. Trial proper start. We'll see how all of that pans out. News Night starts now. A priority for